Okay, let's start. Any questions about logistics of the course or anything at all that comes up for you guys? I only have one thing, and that is I got an email last night, actually, from a student in the media law class I teach at the Graduate School of Journalism, asking for permission to post on the website of that course, which is similar to the course, to the website for this course. And I realize that I may not be clear enough that you have course author status so that you can post whatever you want, whatever you're interested in, and not just reply to what's been posted. Please do, and obviously it's part of participation in the course. And again, if you're not comfortable and want to participate in other ways, that's obviously more than okay, and you can send me emails and we can have conversations in other more private ways if you feel that's more appropriate. But if anybody's sort of holding back, thinking that that I am meant to be the primary carrier of the content on the website, I do that between courses because there's 8 months between courses. But I'm hoping that as much as possible, you carry the website during the semester. So no questions? All right. Today we have Roch Ripley coming in the second hour. Roch is at Gowlings, and he was one of the co-authors of the second edition of the book. And his perspective you will find to be a very refreshing one because it's very different from my perspective. So we are yin and yang, especially on intellectual property issues. So if you feel I'm steering you in a certain direction, and I hope I'm not, but I know sometimes that I am, and I try and give you some sense of balance, Roch brings that balance by the bucket load. So today we are into kind of the middle part of the creating meme, and there's a whole lot of things we're going to do today, and not a whole lot of time. But the one follow-up, and it's in many ways more than a follow-up because it really leads directly into today, is this wonderful piece, when we play video games, who are we? And it really goes to exactly what it says. Who am I when I play a game? And I don't know if anybody has played Destiny. I have, and here's my problem. And this is not about me. Hopefully this is about the subject matter. Every time a big first-person shooter game comes out, a huge one, I buy it in the hopes that I will like first-person shooters or like the experience. And I always find myself bored, and I keep hoping it's different, and I will return to this. But this is about the tool of player creation, and this is a story by a woman whose boyfriend chooses a female avatar, and she's looking at what the boyfriend is putting into the avatar, and it's a very sort of existential piece, and it raises questions about who you are when you're playing a game, and the answer for me when I'm playing a game like a first-person shooter that I'm not comfortable with is I have no idea. It's almost a direct connection to my subconscious. But where that goes is sort of back to our friend McLuhan, who's becoming one of the memes of this course. Identity ends up being important in many of the issues that involve and surround law in games. So if you want a little bit more evidence of this kind of social interaction, which will largely be the theme of today, is that, guess what? In virtual gaming worlds, we organize ourselves in social ways just as we do in the real world. So this will switch gears, but comes back in some interest to some interesting intersections. This is a pretty straightforward piece in WIPO magazine. Are video games computer programs or creative works? That's a really loaded question when you think about it. I don't know if any of you are parents. All of you have parents. Let me confess to you the classic parental trick. When you're trying to get your child to go to sleep and it's getting late, what you do is you frame the question a certain way. You don't say, do you want to go to sleep? That's wrong. Nothing open-ended. Do you want to go to sleep after you've had a glass of milk or after we've read? Classic. Video games, computer programs, or creative works. Those are your choices, A or B. This comes into something called copyright literalism, but I want to show you just a little bit about how this works, because it's rooted in, it's deeply rooted in assumptions and language, and it seems very reasonable on its face, and you have to, as law students, look more deeply. So are specific regulations for video games required? And remember, this is coming from the World International Property Organization, so it's coming from a loaded place of belief around intellectual property, and that's what they're essentially referring to. The time is ripe for an international discussion on the merits of adopting specific regulations for video games. Okay, that's interesting. We need to consider the legal nature of these modern and complex works. No kidding, we're having a course in that, so obviously some of us believe this is complex. But thank you, WIPO. I appreciate it. I've been fighting to argue for the complexity of video game law for a long time. The relationship between creators and producers. Creators and producers. Do you want milk or do you want a story? Gamers? Maybe? Somewhere in here? How to determine who is the creator of a video game. Now you're going down the rabbit hole. The choices are creators and producers. Who's the creator? See the trick? Very good. It's very well done. And now we're into details. Transfer of rights, fair and equitable compensation. We've set the framework. Now we're into the details. And the focus and the rest of it, and I've given you the link, audio elements, video elements, computer code. Once you drank the Kool-Aid, you're sort of done. You have to follow the logical path. So, no mention of the role of gamers, but I would say they're aware of it because it's carefully excluded. The rhetoric is not completely closed in. It's just the old parenting trick. Which brings us back to Boyden. And this is where I want to dig down today and sort of reveal the mysteries that were alluded to last week. So the core of Boyden's argument, and just to take you back, it is accepted that games are not copyrightable. What Boyden looks at is why are they not copyrightable? And he surveys the possibilities and the cases as a good legal academic, as a very good legal academic, the excellent legal academic he is, and comes up with two possibilities after a careful analysis of the cases. One is that games are unprotectable ideas. Remember, we're not talking about video games. We're talking about games. So the root of video games is games. Games are unprotectable ideas. And as mentioned last week, and if you've taken IP 101, you will know about the idea-expression dichotomy. There's no intellectual property in an idea. There is only intellectual property in the expression of an idea through fixation. We went through some of that. So if it's an idea, if a game is an idea, it is necessarily unprotectable. Simple as that. It's just built right into the Western conception. The other possible explanation is that games are uncopyrightable systems or processes. And there are no spoilers here because we're 2 weeks running on when you should have read Boyden. You will know, if you did, that that's where we go. Games are uncopyrightable systems or processes. So this is my thought process. This is my explanation, not Boyden's. How is a game not IP? What really comes to me is the simplest of games. Odds and evens. And if you're trying to conceptualize why a game is not intellectual property, how would you make this intellectual property? I guess that would be the challenge I would. You could write out the rules. We know rules, if we study copyright law, are not copyrightable. Odds and evens is a system. It's a system that is a game. Questions, thoughts, reactions, pushback? So, Boyden then just sort of categorizes the cases in which copyright is denied. Presentation of information, systems that are expressly designed to allow others to organize information, systems of notation, contests and betting systems. Notice that games are not on that list. Why are games not on that list? That's exactly the problem Boyden's trying to address. We know that games aren't copyrightable. We don't know why. So he's proceeding by analogy. In all of these situations, the owners of a copyright, in a form, description, or set of instructions, were attempting to extend their copyright to material for which the user of the work provided the essential content. For which the user of the work provided the essential content. Think of a spreadsheet. The user of the work, the user of the spreadsheet, provides the essential content. That is what made them systems. They were, without that input, empty shells waiting to be filled. Games are systems in exactly the same way. A game is sold. As sold is only a game form. The content necessary for an instance of the game comes from the players. It's existential. There's no game without the gamer. Now again, we are talking about games, not video games. But video games are very clearly on the exact same linear progression. Now, where it becomes infinitely more complicated is that video games are not spreadsheets. Yes, they need the gamer, but they also have art, they also have structure, they have elements that are film-like that very much look like and are copyrightable. So the limited argument that I'm making is that ignoring the gamer just can't be on. I'm not saying that all of the intellectual property in a video game belongs to the gamer. But doing what the Whippo article does, and virtually, pardon the pun, ignoring the gamer is not on. So, creative expression of gamers is the key, and the key to today. So the key is not in the idea-expression dichotomy. The key is not in the definitional elements of intellectual property law. It's saying a lot, because that's where any of us would first look. Let me find this in IP. And so the key brings us back to this process of gaming. And what is a game? And there are some really serious problems that we're going to explore later in the course around this concept. But I assure you, you're going to find it really appealing, at least in week 3. And it is very appealing. It's very elegant. It's the concept of the magic circle. So what do we get? What's our gift from Boyden? The gamer and the game, a system. Our gift from an academic named Johann Huizinga, who died in 1945, so obviously did not play a lot of video games at that time. Depending on what you believe on the afterlife, you may come to a different place. Applied to video games by Salin and Zimmerman, the notion of the magic circle. The magic circle is a consecrated spot. It's mystical. It's a circle in which the rules of the real world don't apply. The rules of the outside world don't apply, and we don't want them to apply. We create new rules within the magic circle. Games are a form of the magic circle. Video games are argued by Salin and Zimmerman to be within the magic circle. And you know, it's unfair for me to tell you, to not tell you the punchline on why this is so difficult. Where it becomes difficult is where video games have come to today. huge, massively multiplayer, open world, interconnected, with very dramatic economic consequences and microtransactions and lots of real world stuff. And it's hard to, as you will see later on in the course, it's hard to fully support the magicness of the magic circle. But suspend that for a minute and just go to the simple idea. The arena, the card table, the magic circle, the temple, the stage, the screen, the tennis court, the court of justice, that should appeal to you, are all in form and function playgrounds. Forbidden spots, isolated, hedged round, hallowed, within which special rules obtain. That's why you're here. You're here to learn the special rules. The secret handshake. The special language. All are temporary worlds within the ordinary world, dedicated to the performance of an act apart. You get that. One day you'll, if you end up being a litigator, you'll experience how strange it is to see a judge that you've just appeared before on the street in a Starbucks buying a coffee. One set of rules in court. Regular person, regular interaction. Your brain kind of really zigs and zags at that moment. The first time it happens to you, you'll get used to it. But the first time it happens to you, it's like, what is going on? Because within the magic circle, a totally different set of rules. So, just brief ad for if someone wants to do a paper on does Boyden apply. Boyden's looking at U.S. law. He's making these distinctions in U.S. law. Does Boyden apply to intellectual property law in Canada as we've constructed it? There's no right answer or wrong answer. Your answer will be the right answer. I can almost guarantee it. So, Boyden's about the gamer and ultimately about the creativity of the gamer. The system is empty without the gamer. The gamer is doing something. What's the gamer doing? The gamer is creating whatever the game is. Okay, so if we're talking about the gamer's creativity, that takes us to the nice legal bottle that we put this stuff in. We call it free expression, we call it free speech. And we're going to talk a little bit about why it doesn't fit so well for video gaming. That may surprise you. So, but first, and I apologize for the grayness of this slide after all the black slides, but it's the only way to make the live links for the cases pop. So it was a conscious compromise for which I apologize. When we think of free expression, when we think of free speech, we just have our usual suspects. Winters in New York, U.S. Supreme Court case, which basically was the first down the pike to say, these restrictions on free speech are too vague. And that notion has carried through all the way to what's known as the Schwarzenegger case, again, which we are going to talk about in much more detail later in the course. Brown versus Entertainment Merchants Association, U.S. Supreme Court case that had to do with the California law banning the sale of violent video games to anyone under 18. and the courts have essentially never allowed them. Sadly to say, the Canadian case is much more boring and doesn't have the flowery rhetoric. There's almost nothing quotable in it. It's really Supreme Court of Canada circa 1985 in so many ways. Montreal versus Arcade Amusements, a Montreal City bylaw prohibiting gamers under 18, prohibiting all gamers under 18 from the physical premises of the arcade, was invalid as being discriminatory. And it's not that I didn't look for a quote. There really isn't one. It's so much easier at the U.S. Supreme Court. At least at that time, so much more quotable. The ironic footnote is that Arcade Amusements, I'm virtually certain from reading the case, was the arcade that I used to go to when I was a law student at McGill. So I'm like 99.9% certain. So now I've told you creativity isn't what you think it is, and the limits on creativity are not really the usual suspects. So what are they? So this is going to start with you. And I don't want you to do anything quite yet. I will want you to do something. No cameras are pointed at you. But I'm going to ask you to self-identify. I'm going to ask you what you really believe about creativity, and I'm going to give you two choices. And this is not a parental trick. I actually believe there are only two choices. If there are more than two choices, I am very open to that. The two choices will be, are you a creator or are you a connector? Do you believe that creativity is about an inner creation, which I'll come to, or do you believe that creativity is about connecting different things, and those different things just sort of formulate some sort of pattern in your mind, and you express that? So for these purposes, I'll tell you a little bit more about this later, but this, to me, was the best definition of the creator feeling. The creative is the place where no one else has ever been. You have to leave the city of your comfort and go into the wilderness of your intuition. What you'll discover will be wonderful. What you'll discover is yourself. So, what's your, is this your feeling around creativity? When everyone in this room is creative. Everyone in the world is creative. It's a basic human function. When you are doing something creative, is this what you feel like? Connectors. And there is obviously no right answer. I mean, you guys are more than bright enough to know there is no right answer, and the world divides itself a little bit along these lines. Creativity is just connecting things. When you ask creative people how they did something, they feel a little guilty because they didn't really do it. They just saw something. It seemed obvious to them after a while. That's because they were able to connect experiences they've had and synthesize new things. So now, hopefully, any questions about these definitions? Now I'd like you to, uh-oh, we're going totally in the wrong direction. All right, now I want you to self-identify. Remember, no cameras are really pointing at you. They're all pointing at me, so no one sees this. I'll put up connector. Who believes that when they create, they are connecting? Okay? Great. Who believes they're creating? Okay. I will say from past experience that that is roughly the law school experience that I've had. What's really fascinating is that in other faculties, in other institutions, it changes. I gave a talk to a very large room at Georgia Tech last year at this time. No law students, all engineers, because that's what Georgia Tech is, right? They don't have a law school. They do have an undergraduate arts, but for the most part, you've got 18,000 engineering students there. The room was almost all connectors. I do this at the Center for Digital Media, and I'd say it's 60-40 creators.
What was the rough percent here?
I would say it's 70 connect, 30 create. I don't know if anybody looked around the room, but that's sort of the rough percentage that I see. And I'm going to show you why I think law students are 70% connectors. I think there's actually a reason for that, and a very, very simple reason for that. But again, this isn't right or wrong, but it is important. So the connecting mentality, and again, there's a lot of good publicity for connecting. Steve Jobs being the best publicity, because he said in a Wired magazine interview, a very famous one, which you can link to, creativity is just connecting things. It's probably the best known quote. There's some deeper ones. All creative work is derivative. This is really interesting. Stephen Johnson has a wonderful TED Talk. The great driver of scientific and technological innovation in the last 600 years has been the increase in our ability to reach out and exchange ideas with other people, and to borrow other people's hunches and combine them with our hunches and turn them into something new. I particularly like Carl Sagan's. It's very philosophical. If you wish to make an apple pie from scratch, you must first invent the universe. A really cool way of saying everything's interconnected. Now, creating, there are reasons, deep reasons, why we hew to the message of creating. So the quote that I gave you comes from one of my favorite actor-producers of really the 20th century. So it shouldn't be a complete surprise it's coming from Hollywood. Hollywood has that particular personal creation mythology. It doesn't mean it's all ego-based, but some of it really is. But I think if you're looking for a deeper reason, I think you have to look at the Bible and how it, Genesis is a creation myth. And it's what a lot of people project onto. God created the universe. The first creator, and we are, whether, this is not about religion, this is sort of, let's put it in cultural anthropological, in a cultural anthropological context. We believe ourselves on a variety of levels to be made in the image of God. I don't know, not just the literal biblical version. And so we must be creating from nothing as well. It's not hard to find these antecedents. The irony, of course, is that the creator myth is just our connecting other things, but that's way up there. So what's the result? And this is really where I'm going to. Where I'm going is maybe if you look at the exercise, it becomes easier for you to understand why there's the divide that you see around issues like intellectual property. And I'm suggesting that some of these alignments are not simply IP issues and freedom of speech and expression issues, and I'm suggesting these are what do you believe issues. What do you believe about creativity? If you believe that it is creation ex nihilo through you and only through you, then you're going to look at the notion of intellectual property a certain way. And I go, well, IP is property. It's mine. It came from me. And you're going to be more protective of that standpoint. And if you don't believe that, if you just believe, wow, that came through me from somewhere else, and I don't even know where that came through from, then you're more likely to believe in open source models and user rights and things like that. So I tell you this not in any way to change what your beliefs are, but so that you can use these concepts, understand where other people may be at, and understand maybe someday when you're practicing in the area what the deeper point is. Now, all of this is incredibly relevant to games for an obvious reason. And that is that games have become not just the interaction between the gamer and the game, and we now know how important the gamer is in a variety of ways, but increasingly, throw in Minecraft, where the art is not the fantastic part, but where the act of creation and the act of connection is the fantastic part. So, a couple of other just quick notes as to why there's a 70-30 split. If any of you submitted a paper to me without footnotes, without building on the works of others, you would almost certainly fail, no matter how brilliant that paper is. I'd like to leave myself some wiggle room, but as a general rule, footnote without papers, without building on the work of others, is going to fail. So, and you're here, this is a remix culture, obviously. Now, what you're studying is a remix culture. Just try going into court, especially in your early days, and not citing cases. Let's see how you do. So, again, these aren't about right and wrong answers, but if you're looking for reasons why, in certain places, you get certain results to creator versus connector and not in others, this is why. I've never done that outside an educational institution. So it'd be really interesting to do it to a group that, that have nothing to do with education, per se. And I think we get way more creators than connectors, but I don't know. It's something over time, I'm doing it. So speaking of the usual suspects, let's do our survey of creative expression, of freedom of expression. You guys know this really well. conscience, thought, belief, opinion, expression, press, media of communication. There's your litany of free expression, U.S. Constitution, no law abridging freedom of speech. Older legislation, narrower choice of words, Universal Declaration of Human Rights, Articles 18 and 19. Again, thought, conscience, opinion, expression, seek, receive, and impart information and ideas through any media. So this is kind of the current 20,000-foot look at what freedom of expression is. I just, if anybody's looking for a sleeper in all of this, mine is freedom of thought. And it'll come back up in the course, but there's very, very little work that's been done on freedom of thought. And when you consider privacy, surveillance, big data, brain research in the context of freedom of thought is an area where a lot of work can be done. And I think that where you're going to see a lot of work being done over the next many years. And you'll certainly hear more about it from me. But when we're talking video games, in the context we've been talking about it, where am I going to find, where are you going to find freedom to create? Is it here? It's sort of implied. It's between the words. It's not really in the... Is creation opinion and expression? It's kind of between. So in legal terms, the closest I think you're going to get to it, if you want to go back to your first year law school stuff, is obscenity laws. Because when you read those cases, whether it's in a Canadian or an American context, there's some value given to the art. But it's really, and when I say the art, the creativity of usually the writer. But it's hard, and again, I would welcome pushback, to find it in too many other places. So when I'm in trouble, I always go back to Areopagitica. Everybody should read Areopagitica if you have any interest, any real interest in freedom of expression. It's written in 1644, and I still can't find any argument that's not in it in favor of freedom of expression. It's a surpassingly brilliant piece by John Milton, and just a couple of quotes. And this is in the Old English, so apologies. Books are not absolutely dead things, but do contain the potential of life in them to be as active as that soul whose progeny they are. These are quotes, as you will probably figure out before I tell you, I've picked for a purpose. Talking about truth. Let her, truth, and falsehood grapple. Whoever knew truth, put to the worse in a free and open encounter. Very famous one. Lords and Commons of England, consider what nation it is ye are, and whereof ye are the governors. A nation not slow and dull, but of quick, ingenious, and piercing spirit, acute to invent, subtle and sinewy to discourse, not beneath the reach of any point the highest that human capacity can soar. Now in yellow, what I've highlighted are the connector pieces. You know, this is a seminal work. This predates the American Constitution, the Charter, Universal Declaration of Human Rights, and yet it contains the link between free speech and expression and others. The word discourse, free and open encounter. Encounter. All of this happens in the context of other people. Books are not dead. They interact with the world. So there's a world to interact with. Brings us back to Sagan. Now, all of this is to say that I'm arguing for a right of creativity, a freedom to create. But every time we go into the realm of rights, we kind of go in loaded for bear. And the problem in this area is, what rights are we talking about? We got just in games, we just got a ton of rights to deal with that all affect the video game. We have many flavors of freedom of expression, which we've talked about. We've got the game developers, we've got the gamers, we've got probably, you know, if we actually broke it down, the distributors, the stores, etc. You know, we have them all. We have privacy rights. We have intellectual property rights. And that's just some of them. So we end up with this clash, which you know again well from first-year constitutional law. And the problem is when you have dogma creep into rights, and some of you will know of Aaron Swartz, who tragically committed suicide. This was a statement from the U.S. State's Attorney Office at the time of his charge. Stealing is stealing, whether you use a computer command or a crowbar, and whether you take documents, data, or dollars. It is equally harmful to the victim whether you sell what you have stolen or give it away. There are so many ways to parse that, especially from a law student's perspective, and attack almost every word. I think, in terms of legal analysis, couldn't be more wrong. But when you're coming from a literalistic or dogmatic place, you can take intellectual property law and be a literalist about it. You can take freedom of expression and be a literalist about it. You can take privacy and be a literalist about it. And this is the kind of, frankly, nonsense that comes out when you do that kind of thing. So let's talk about that. And I want to give you an example because it's sort of my favorite one to illustrate this. Let's take the privacy literalists and the IP literalists. And let's examine their contradictions, at least in political terms. The IP literalists, many of them, I don't want to say it's absolute, seem quite comfortable with commercial exploitation of personal data. It's really an odd anomaly, right? They're saying, copyright is property, it's my property, I get to do what I want with it, but many of them say, but I can use your data commercially how I want to. So there seems to be a double standard there. The same double standard exists on the other side of the equation. The privacy literalists tend to be the open sourcers. Share alike, but not my data, just what I want you to have. And, you know, I do take a side on this, but that's irrelevant to this class, you probably can guess. And you can distinguish these things. But I think what's far more interesting is to say, gee, if we can find a model that works conceptually for both, then maybe we can move forward. And I think the model that can work, possibly, I'll go through this quickly, is a feeling that those ones and zeros, that digital data belongs to me. Whether it's on the intellectual property literalist side or the privacy side. The common denominator is we got a bunch of ones and zeros, and only I should be controlling them. That seems to be the common denominator. Now, there's this really interesting notion of moral rights. Anybody ever hear of moral rights? Moral rights apply in Canada, and we will look at them in more detail, but they are part of Canadian copyright law, and they don't exist in the United States. There's something really interesting about moral rights, but which we will get to. The best known moral rights case, very quickly, is Snow versus the Eaton Center. Snow is a sculptor and an artist, and he made a giant mobile for the Eaton Center of flying geese that hangs, if anybody's been at the Eaton Center in Toronto, that's kind of at the center of the Eaton Center. Anybody seen this? Okay. So the Eaton Center, Christmas was coming up, and people at the Eaton Center decided that it would be cool to put Santa hats and other Christmas paraphernalia on the ducks. And Snow took them to court, sought an injunction, relying on his moral rights as part of Canadian law to say, no, I don't want that. I'm the artist. I didn't make it for this purpose. Yes, I sold them the ducks. Yes, there's a contract that it belongs to them, but they can't actually do anything they want with it. And again, we'll come to this in more detail. The court said, Mr. Snow, you're right. The Santa hats have got to go. There's something really interesting about that. Here's one kind of from the side of the spectrum that I tend to side with, but recent piece. The copyright monopoly's fundamental problems remain the same. We're at a crossroads. We must determine what is more important, the right to communicate in private at all, or the obsolete distribution and manufacturing monopoly of an entertainment industry. These two are completely mutually exclusive and cannot coexist. So here you've got someone who's very much pro-users' rights, taking a very literalist approach. So I just want to show that this happens to everybody. It's a human characteristic. So how do we reconcile this? Well, what's really interesting about moral rights, tying into what we were talking about before, is it seems to be the only legal concept that assumes creativity. And I will defy you. I tried to lead you through the charter and the... I would defy you to find me, and actually I'd be thrilled if you found me, a legal concept that assumes creativity. We don't have enough of them. And here we are talking about video games as a digital technology in an interconnected world. And all the signs that we're going through, I'm trying to be as objective as I can, point to creativity being the core factor. And yet we have very few we have very few legal concepts. Now, you're probably going to say what I was about to say. That would be great. Go for it.
I hope it would make me feel very intelligent. Doesn't copyright assume the expression of an idea, which in itself implies creativity?
I will go. It talks about expression. It talks about an idea. We know, and I'll take you back to Atari and Oman, that the threshold for creativity in copyright law is very low. So, but I accept your point. I do accept your point. That's not totally where I was going to go, but I'll come back to what I thought you were going to say. So what I thought might come up is the Supreme Court of Canada's pentology, which is quite user rights based. But I'll just point out that even though they got very, very close, certainly in the educational decisions, why are we having education? Essentially to create the notion of users' rights is based on users. So the actual rhetoric. So I think moral rights very, very directly acknowledges creativity beyond an idea. But I have to acknowledge you are absolutely right in terms of the core. I think moral rights goes further. And where this ultimately comes down is, do you believe that creativity is more important than property? Because, again, I'm not trying to be the parent here, but that seems to me, on reflection, to be the choices. And I may just be stating it a little bit more politely by saying more important than the article that I sort of criticized. But that seems to be where we're at. And all video games are, as I've tried to demonstrate, is proof of mutually reliant and merged creativity. Keep on coming back to Minecraft, but, Notch sold it for $2.5 billion. So whether it was worth that or worth close to that, mutually reliant and merged creativity obviously has resonance and clearly has value. So can we evolve a single standard for creators as users and users as creators? Oop. And that's the question. And that brings us back to, are we going to establish a right to create? Currently, when you look at intellectual property law, it's a right in the creation. And that's the key. Whether you want to call it a property right, and we can get into how that's a misnomer, and we will get into it. And this sort of goes to what you were saying. There is a creation of some sort. You have a right to it. As opposed to the right to create. And what I'm saying is moral rights gets me somewhere down by providing remedies that could only result from having had a right to create. Still doesn't fully do it. It's as close as I can get. Now, one more last thing, because I don't want to hold up Roch, but he knows this well because this is one of the points that we debate. There's this wonderful piece a number of years ago where actually the law librarian at Duke noticed something very simple, and we will talk in different contexts about the difference between causality and correlation, mostly about on the subject of violence. And causality and correlation is a very dangerous trap to get into, and he notes that. But he noted the correlation between strong economies and weak IP laws. And said, gee, there's a correlation. Could this be causation? And he did it in what are called the BRIC countries, Brazil, India, Russia, and China, who had strong economies and weak IP laws. I was really unhappy about that because those countries don't always have respect for fundamental rights. So I wanted to see if there was a way of formulating, look for correlations between economic success, facilitating creativity, and a respect for fundamental rights. And so I went to a bunch of sources, and this is extremely unscientific. But I did find that if you're looking for those three things, and they're various, World Best Economy, World Justice Project, and something called the Global Creativity Index, that countries like Sweden, Finland, and Denmark seem to have all three to a certain degree. And what are their IP laws like would be the question. It's just a recent article that raises the same question. Roch's response to me was, well, Switzerland. Switzerland has strong intellectual property protection. And it would appear to be one of those countries. Except, my retort is, look at what Switzerland doesn't make games. Doesn't make video games. Not a strong part of what it does. It makes watches. It makes all these other things. But the creative industries are not the bulwark of the Swiss economy or anything like it. Oop. So, and then one other piece that you'll find on the website that is, you know what, I'll show you, I'll give you a link to it actually on the website, but a wonderful talk at Harvard on Nollywood, and which makes the connection between weak IP laws and a very strong film industry. So next week, we're going to go at this very, very directly, essentially doing a case study on mods and remixing in games. And that will be the end of this trilogy on the creative meme. And hopefully, it will help you come to some answers. We're going to take a 5-minute break. I'm going to wire up Roch. He's going to do all the retorts of me that are necessary, and we'll go from there. So I have the pleasure of introducing. Everything okay?
Yeah, I muted it, and now I've unmuted it.
Oh, okay. Makes sense. So Roch Ripley is the co-author of the second edition of Video Game Law. He did an enormous amount of work on this. And is a great friend, a great colleague, and a great debater with me on intellectual property issues. Always want to bring him in as early in the course as possible to be a countervailing force against the deeply dangerous road I'm taking you down. So
You're a communist socialist. And I think the best paper would be entitled, Why John's Wrong. 20 pages on wrongness. Anyway, thanks for the introduction. So hello, I'm here to talk about all these acronyms, EULAs, end user license agreements, terms of use, non-practicing entities, WTF. Basically, EULAs and terms of use are going to be about how contract law has overridden or changed a lot of the common law, which historically has been the foundation for what we consider fair. Trolls are just something that is topical, and notwithstanding changes in the law and changes in behavior remain topical. And why these two topics? One, we spent a lot of time actually on the first two when we were working on the second edition of the book. And it dovetails quite nicely into a lot of stuff John likes to talk about, which is, abrogation of a lot of our traditional rights. To really, just to give you some ideas for papers, a lot of the, we'll go over some cases and we'll talk about what they stand for and stuff like that, but there's not a ton of value in that, quite frankly, because you can all read the cases yourselves and you can all figure that stuff out. To the extent that we can make some connections, or your interest is piqued, or you think about something in a different way and you want to explore it further, I think there'd be a lot more value in that. Personally, a lot of the stuff I like to read now involves research that is more than just case law. Lots of times, as lawyers or law students, we default to doing a lot of case law research. It's what we're good at, it's what we're trained to do, but I think the really interesting stuff is where you do a lot of hard work, data mining, or figuring out what's been filed where, who's doing what deals worldwide with your free subscriptions to Lexis or Westlaw or what have you that end as soon as you graduate, and all those wonderful things. So to the extent you want to go beyond case law research, I think that's actually quite fertile ground. So let's forget about EULAs in terms of use and just think about the jurisprudence. So where does the jurisprudence before all these contracts, where does it take us? So starting point, games are protected by copyright. I'm sure John's already talked about Atari v. Oman because I was here when he just mentioned it, so I am sure of it. And if the lecture was like last year's, he would have talked about it last week. So they're protected by copyright. One interesting thing there, I don't know if you follow any of the case law, copyright case law that's coming out of the U.S., but Google and Oracle were just in, they might still be in, I don't know if they're appealing it. In any event, there was a decision that just came down with respect to copyrightability of APIs, application program interfaces, and the Federal Circuit said they are protectable by copyright, and lots of people had their arms up in the air and were saying that's ludicrous, that's crazy, it's not protectable, it shouldn't be. Query whether or not that's sort of your, or a person's gut reaction to copyright being arguably extended, arguably not even extended to something people are just unfamiliar with, and where they're just playing out again like it did with games and like it did with many other types of media or subject matter. Reverse engineering's okay. We'll talk about a couple of those cases that talk about when it is okay, Sega v. Accolade, and when it's not, Atari v. Nintendo. When you enhance a game without creating derivative work, that's fine. That goes to the Game Genie case. Okay. I'll talk about those cases now. I thought I had an extra slide, but I don't. In any event, the game, do you guys remember the Game Genie? Do you know the Game Genie? Yeah, so if you don't remember the Game Genie, it was this, when games were on cartridges, and you had to put the cartridge into like your Sega Master System or something else, you would have the Game Genie, which was a double-ended cartridge. You'd stick your game on the top, you'd stick the bottom of the Game Genie to the machine, and you could do things like give yourselves lots of extra lives or or unlimited power or something like that. And the issue Nintendo had with that was you're you are altering the gameplay experience. And for various reasons, gaming companies don't want that to happen. So they commenced suit, and Gloob's response was, we aren't actually infringing your copyright. We are enhancing what you've done. We aren't taking it and changing it so much as we are adding to it. And that was persuasive in that case. And those two cases above, Sega v. Accolade and Atari v. Nintendo. So both Nintendo and Sega, back in the days when Sega had a system and Nintendo system was the most popular system, employed little digital barriers on their devices that would prevent non-licensed games from being played on them. And of course, the benefit there is if you want, as a publisher, to be able to use those systems, which were the only systems on the market, you had to pay your license fee. And publishers did not always want to pay the fee. So what Atari did was they tried to reverse engineer Nintendo's code. They couldn't do it. They went to the Copyright Office and under false pretenses got a copy of the code. And in the United States, when you want to register your copyright, you have to submit at least part of your code. And from that copy of the code they got, were able to reverse engineer that digital gate, bypass it, and get their games on the system without paying Nintendo anything. Lawsuit was commenced. One of Atari's defenses was, we're exercising our right to fairly use your copyright. And the court decided, well, the defense is fair use. What you did was not fair. You got that code basically by lying. So we're not going to let you rely on the defense. And contrast that with what happened in Sega v. Accolade, where Accolade did successfully reverse engineer Sega's little bit of code on their system without relying on false pretenses, and their fair use defense was held to be just fine. The last point there is copyright exhaustion. You're probably aware. I mean, if you have copyright in a product, you sell the product. Standard rule is you have no more ability to enforce the copyright in the product which you have sold. And there is a case later in one of the slides that talks about how that has been and can be modified. So some recent cases that sort of depart from that starting point. One, you talked about this case yet?
Not yet.
Okay.
So this is, it comes later, but this is a great introduction.
Yeah.
You should give them the teaser on it.
Okay. Well, John loves this case. It's a good case. I mean, it actually is a good gateway to a lot of the... Oh, look at the name Gateways, and I never noticed that. Anyway, it's a good gateway to a lot of the issues that the course talks about. So what happened here was Blizzard... you all know Blizzard, World of Warcraft, StarCraft, all these games where most of the value is going online and playing against other people. You don't want to just play against the AI. So a long time ago, they launched their Battle.net service, which was a service where all the users, if you had a legitimately purchased version of the game, could log on and play against other people. But the key there was, it was really ingenious. It was way better than the CD key. I mean, back in the days when your only authentication was a CD key, all you had to do was use your friend's key or go online and see what keys were published or do these other things that really allowed you to easily circumvent the protection of the game. And there was no downside to doing that. And one of the great things from Blizzard's perspective about Battle.net is that not only could you have this platform, which was a great value add for your gamers, but you could check to make sure everybody had their own authentic CD key. So people wanted to play, they actually had to buy the game. And what happened in this case was the defendants, who were avid gamers themselves, started their own competing Battle.net type service where you did not need a valid CD key to play the game. And that was in direct contravention of the end-user license agreement and the terms of use that everybody agreed to when you sign on to play World of Warcraft or StarCraft or what have you. Actually, then it wasn't World of Warcraft, it was just Warcraft.
Yes.
And there are a couple excerpts from their terms of use or their end user license agreement that fairly clearly say you can't take our code, use it as a foundation to create a competing service, and then offer that service to other people.
Roch, I'm going to remind you to stand
Oh,
near
in
the
the
table. It's exactly
Right here?
what you did last year, and then you never.
Then
Yeah,
I-
if you're
then I
right there,
vanish?
you're fine. Yeah.
Okay, I'll stay here. So what are the takeaways from this case? One, the defendants tried to argue fair use. They didn't commit fraud. They actually tried to cooperate with Blizzard and get that code that would require everyone who played on their competing service to have a valid CD key. Blizzard just didn't want to cooperate. Entirely their right. So they said, well, what we did was fair use of the copyright, and the court decided, yeah, but you agree to these contractual terms, so that defense is not going to hold water. Another important holding in this case was an application of the DMCA. Yeah.
So I was wondering if you somehow modified the game so that you didn't have to agree to the end user license before installing it, would you be able to get around this contract?
I think we'll get to that in a sec. There's another case where we can touch on that point. So hold that thought, and we will get there. I think the bottom line is, though, they're going to get you. That's the takeaway. A violation of the DMCA, the Digital Millennium Copyright Act, which was a statute passed probably 10 to 15 years ago now, which added protection for digital locks. And the digital lock was basically over and above the actual copyright someone has or Blizzard had in the game. It was a mechanism that would prevent you from copying certain elements of the game. And because there was no CD key required to play on the competing Battle.net service, that CD key, which is an anti-circumvention device, was circumvented, and that was held to be a violation of the DMCA. There's another case passed in 2010, similar kind of reasoning and issues. And you can have a look there, Blizzard v. Allison Reeves, where she had her own private server. Another Blizzard case, MDY Industries and Blizzard, and this was about a bot. So the bot was called Glider, and what Glider basically did was, instead of forcing someone who bought the game to play it for hours and hours and hours to become super powerful, you could run the bot and it would play the game for you, and you would go to work or go to school, and you'd come back and you'd be magically super powerful by virtue of what the bot did for you. To prevent people from playing the game in this way, Blizzard had an anti-circumvention device called Warden, which would check your computer memory and see if you were using this bot or not. And if you were, it would take action. I think it would ban you from the game or kick you off or something like that. Again, relevant terms and conditions from the EULA and the terms of use with respect to using bots. Basically, can't use bots.
And just to be super, super clear, if there wasn't a terms of use or a EULA, and you were dealing just with intellectual property law, would Blizzard have had a case?
And no DMCA?
No DMCA.
I don't think so.
Yeah.
I don't.
So that's really the point to focus in on. And a comment would be great, is what end user license agreements bring to the table. Now, DMCA is also a particular statutory provision, so you can't say there is, that's a fictional world that doesn't exist. But if you had no contract, you'd have a very different situation. And what's key is, as Roch alluded to, is to understand how contracts have really circumvented intellectual property law in many particulars, especially in the realm of video games, although not restricted to that.
Sorry, I was just going to ask, you said if there were no DMCA as well, how would the DMCA apply to a bot? Just wondering if either of you could clarify, if there were no EULA in place that said you can't use this.
Yeah, I think that's a good.
I think it would still apply. The DMCA doesn't say, it doesn't reference terms and conditions or a EULA. It says if there's an anti-circumvention device, you can't circumvent it. And the anti-circumvention device is this Warden program that Blizzard included as part of the game.
That would have had to be circumvented.
That would have had to be circumvented in order to use the bot. Okay. Yeah.
In the same vein of using a program or a web to circumvent it, surely if, I mean, the whole idea is that when I install the game or start up the game or I purchase the game, it's me as a user agreeing to the EULA.
Right.
And me as a user being subject to the DMCA and anti-circumvention tools that Blizzard is used. But in the same vein, if I ran a program that once I put the CD in, starts up the thing for me, installs it for me, so it's not me that's installing it, it's my bot that's installed the game while I'm at work, and that runs the program while I'm at work. In that same vein, would that affect the EULA or the DMCA? Because the active user isn't me, it's the program.
Well, I think the law of agency would apply there. If you're the one installing the bot and you run it, then I don't think a court would say you've escaped liability by virtue of acting through a bot. In this case, I also don't think the bot installed the game for people. You would have installed the game first, then gone to the website, the defendant's website, downloaded the bot, and installed it yourself. So you would have already agreed to those contractual conditions.
Now, if you could get into a time machine and be younger than the age of majority, that might work.
Yes, time machines I don't believe have been litigated, but that would be an interesting issue.
And just to remember that if you're underage, you can't necessarily enter into a contract.
Yeah, yeah.
And end user license agreements and terms of use are contractual.
Yeah. So as the holding in the case, liable for breach of contract and a violation of the DMCA. There are actually two prongs of the DMCA that are potentially relevant. One is what's called the copy control prong of the Act, which takes effect when there's actually been copying of the protected work. And one is the access control provision, which is where you've circumvented the digital lock, regardless of what you've done with the underlying protected work. And here, there was no copy control breach because there was no infringement found, but there was still the access control breach. But important to remember that a breach of contract is not the same as copyright infringement, primarily because of the remedies. Breach of contract, usually the remedy is damages. Infringement of a property right, you're opened up to equitable relief. So an injunction, statutory damages under the Copyright Act in this case. So not all liabilities were created equally.
You have a question?
Oh, sorry, I didn't see you.
No, it's good. I'm just wondering, with a game like World of Warcraft, which is constantly being developed and changing, can Blizzard force a new EULA on the user whenever they like, after you've already paid for it?
Yeah, they'll push it to you, and they'll say agree or don't play. Yep. If I don't see you, just yell at me. So another case, a little more recent, Blizzard v. Ceiling Fan Software. So this related to something called map hacking or getting rid of the fog of war. You know what the fog of war is in World of Warcraft? Basically when you're playing, this isn't in World of Warcraft, this is StarCraft. Entirely different craft. Basically when you're playing, StarCraft, there's a big map that you play on, but you only see little bits of the map where your characters are. And that makes the game a lot harder than if you see the whole map, of course, because you can't see what your opponent is doing, at least at the beginning before you have people out there. And here the hack was to get rid of that. So if you were playing, you could see what everybody was doing, which, of course, is an incredible advantage in multiplayer gaming. So there's a snippet from the September 2013 judgment, which summarizes what the defendants do. They sell those 2 bots or license those 2 bots that assist in gameplay. And of course, we've seen the provisions, but the terms of use in the end user license agreement don't permit that usage. So on summary judgment, there was a finding that the defendants were liable for various reasons: tortious interference with contractual relations, unfair competition, and breach of contract. And the result was an injunction against the defendants and significant damages. I think about $7 million. I can't remember the exact number, though. In any event, significant enough to shut them down. Oh, contractual. Contract. Yeah. So I didn't have access to all the documents in the docket or all the pleadings. I mean, a few questions I had reading it: why didn't they apply the DMCA? Maybe because it was a summary judgment motion and the DMCA issues were not clear enough to adjudicate on summary judgment. Maybe because there may not have actually been circumvention. You can see there that the bots were designed to be undetectable. They don't inject themselves into a computer's memory, and they can't be detected using standard technical means. So, query whether or not you've got circumvention or you've just got a poorly designed warden guardian module. I know there is DMCA case law on that as well. And that little bullet at the end is actually something the defendants had put on their website. So there was a FAQ, and the question was, is Pocket Gnome a violation of the terms of service of World of StarCraft? And the answer was yes, it's absolutely against the terms of service. There are not enough superlatives in the English language to fully convey how against the rules what I am helping you do is. If you get caught, you will be banned. Be smart, don't get caught. So, I mean...
But buy the software.
Yeah. So, I mean, the problem here, tortious interference with contractual relations, also intentional interference, unfair competition law invokes the idea of fairness, injunction, which is the equitable relief. These all take into account state of mind and clean hands and all these other wonderful things. And if you're going to go on a website and put all these things on, this is stupid. So don't do that. That's the takeaway there.
What about if this was a single-player game?
What about it?
So it's not multiplayer. You're not affecting anyone else. You're just getting through the game quicker. I'm playing a single-player mode. I just want to get to the major battles quicker. It's not affecting anybody else. What right does the game company or the developer have to make me eat my spinach and force me to play parts of the game I don't want to play?
Well, I don't think the legal analysis really changes until maybe you get to damages. The economic incentives for Blizzard would probably change.
Yeah.
Because the whole issue with this is it affected their online multiplayer market, which is big, really, really big.
But let's say it didn't.
But let's say it didn't.
And why? So what's the sticking point as to why the legal issue doesn't change?
Well, so why were they held liable? Tortious interference with contractual relations. That goes to the terms of the contract. The terms haven't changed.
Right.
Unfair competition law. That was very closely related to the tortious interference claim. And breach of contract, well, the contract doesn't change. Right. Yeah.
So I've signed something,
Yep.
agreed to something that's absurd, and I'm stuck with it. Okay. And
Yeah.
that's just a setup for where we go in 2 weeks.
Yep.
Oh, question?
Oh, sorry.
Sorry, so
Yeah.
if we contrast this hypothetical with the Game Genie case, is it just that you didn't agree to any sort of EULA when you bought your Nintendo cartridge that you snapped the Game Genie onto?
Yeah, there's no EULA there.
There's no EULA.
Okay.
Yeah. Plus, I mean, the kid was probably 10. So even if there was a EULA. Any more questions? Okay. Another case, Werner v. Autodesk. This goes to copyright exhaustion. And it's not a game case, but it is a software case. So Autodesk creates the AutoCAD software, and it's a very expensive piece of commercial software that's very useful in engineering and various other applications. And when you are buying the software, you're really buying a license to the software. And one of the terms of the license was you can't use the software outside of the Western Hemisphere. You must destroy the software previously licensed to you, including any copies, et cetera, et cetera. You can read the last 3 lines. And here, the purchaser tried to resell the software, I believe, on eBay or some other auction site. And the issue was, well, could they do that because on its face it violated the license agreement, or did copyright exhaustion apply here, in which case the owner of the rights had no more rights to enforce? And the decision was that the software was licensed pursuant to that 3-pronged test, that the purchaser of the license was bound by those terms and could not resell it. We have another Blizzard case, and Blizzard is involved in a lot of cases you see, I think just because they make so much. I mean, their games are great, and 2, they're very profitable, and they're profitable in large part because of the gameplay, which is guarded by, in one way, not allowing bots to play the game for people. Blizzard v. In-Game Dollar. This was about a variety of things, but for our purposes was about gold farming. So instead of you going out there and having to play the game and earn all this gold, people would play the game for you, not using your account, using their own accounts, I think. And then at the end of the day, transfer the gold they earned to you. So you come home from work or school, and look, you've got all this gold, you're rich. Again, relevant portions of the various agreements people signed on for. And the end result, I don't think this even got adjudicated. I think the defendant decided it's too expensive a fight to fight. So that ended. So why the motivation to enforce? We talked about it earlier. Multiplayer gaming is really big business. You can see that photo there. That's an actual photo I found yesterday of people watching a StarCraft 2 event. Twitch, which basically is a channel for broadcasting gaming competitions, was just bought by Amazon for $1 billion. And just a local example of how it's having an effect. There's a conference out in Kelowna every year that's getting more and more popular called MetaBridge, and they basically say the top 15 startups across the country can come pitch for Silicon Valley dollars. And I was there this year, and 2 of the 15 related to online esports. So one, WT Fast, which was about increasing the broadband you have available for playing, and one, Battlefy, which is about setting up a virtual stadium to allow people to compete in. So it's big money. And that, of course, influences how you're going to decide to enforce your rights. So that's the first part of the presentation. Before I move on to patent trolls, does anybody have any questions about all that stuff and before? Okay. So patent trolls are non-practicing entities. They've been around for a long time, but have come into prominence more recently, particularly in IT, information technology. So why? In '98, there was a pretty influential Federal Circuit decision called State Street Bank that basically was permissive when it came to business method patents. 2, there was the dot-com economic boom and bust, with a lot of companies filing a lot of patents during the boom and during the bust, selling them off. And you got very good litigators working out contingency for NPEs, which makes litigation easier. And in some cases, the actual patent owner will assign the right to the law firm, and it's the firm that actually commences the suit. So here's a chart showing U.S. business method patents by year. It's a little out of date, but it's a fairly good indicator still of those trends I just talked about. You can see the big spike at about, 99, 2000, which was the dot-com boom. Then the bust around 01, 02, and it leveled off, but it hasn't leveled off to the same degree as before State Street in 98. And I would imagine now it's actually lower. I would guess, I don't have the stats, I would guess, I wouldn't be surprised if it's gone down still, but I don't know for sure. And these numbers are current at 2012 to show you, in terms of all patent suits in the United States, how many were troll suits and how many were non-troll suits. So if you can't read the font, the light blue is troll, the dark blue is not troll. And clearly there's a huge percentage that are troll suits. Same thing with defendants. How many are defendants in troll cases versus not? And if this is something you're interested in, I mean, I was updating this presentation yesterday, and there's just a ton of stuff out there on trolls and gaming, just a ton. So how does the law respond to a problem? Well, a few ways. So the jurisprudence has evolved since 2000. It's a lot easier to invalidate patents, as obvious now. It's a lot harder to get a permanent injunction if you win a patent suit and you are a non-practicing entity. And very recently, not just very recently, but a decision is on point, came down very recently about statutory subject matter. So never mind whether your invention is actually new or inventive, the very fact that it's directed at a software-based invention is that a legitimate thing in which to get a patent. And that's another grounds for invalidity. And that, in the few short months it's been available, has actually been quite a powerful tool. There's been a statutory response as well. So in the United States, the America Invents Act, procedurally it's harder for trolls to commence suits against a lot of people. And there are new ways to challenge patents administratively without having to take them to litigation. And the executive in the United States, President Obama, has quite vociferously said this is an issue and has his own task force. Interestingly, it's not much of a problem up here in Canada. You look at the numbers, and that's primarily because we're just not a big enough market.
It's a big problem for BlackBerry.
Yeah, but not because of Canadian lawsuits.
No, not at all. But
right. Oh, if you're.
But if you want to look at one of the root causes of the demise of BlackBerry, you have to look at non-practicing entities, and there's a pretty good case they were victimized by one.
Yeah, I don't think that's why they've done quite poorly the last several years.
I think there are a lot of reasons. I agree with you why they did quite poorly, but that was at least overtly seemed to be a trigger point. And things seemed to be going just swimmingly before that happened and not so well afterwards. So again, we're back to causality versus correlation, but at least on a certain level, it was the first really big dent in the armor.
Yeah.
Okay. I'm not defending them. I moved away from BlackBerry the first chance I had. So.
But it's a good point in that when I say not a problem in Canada, I don't mean not a problem for Canadian companies that are very big and successful. Quite the contrary. I mean, not a problem in Canadian courts. And that's because our market is probably a little smaller than California. So it doesn't really make sense to fight a war up here. So to conclude, where are we in terms of this balance between contracts and IP? I mean, you probably know where John stands. Where do you stand in terms of one side versus the other, or is that even the right way to put it? Because if you frame the problem in adversarial fashion, that's going to frame your analysis. Was there ever a legal sweet spot where you would say everything was fine? Are we there now? Are we not there? Were we there before? How would you change what we have now to get there? And what do you think the job that courts or the executive or the legislative branch has done reacting to technological change? Just some food for thought. I really should have added, why is John wrong? That's actually, I'm doing that next year. I'm doing, fifth point. Why is John wrong? And that's it. So if you have any questions, I'm happy to talk. Otherwise, thank you very much.